Hypocrisy.
Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I saw you in the chat. I saw you. I'm early. Take that. I'm early. Just kidding. I'm not kidding. I am early. Don't worry about it. Sometimes it happens to guys. Leave me alone. Okay, we are going to, I'm not gonna pussyfoot around and like spend a bunch of yada yada time as people filter in. I know I'm doing that right now, but we're gonna really compress it from normal because I have 2.5 hours. We're gonna get further into this hearing, and we're gonna see how it develops, where it goes, and then I have an entirely different plan for tonight. Tonight we are going to, oh, where's that? Yeah, sorry. Tonight at 11 p.m. Central, I'll be setting up the show in just a little bit so people do know. 11 p.m. Central, Megan Fox will be joining me, and we are going to go through this hearing that is related heavily to the Laura. Well, it's part of the Laura Owens case. That's the tonsil twin chick. That is the chick who allegedly gave a little bit of neck to the Bachelor competitor. I can't remember his name. Aaron, it's not Aaron Eckert. That's the actor. It's some other guy. Anyway, and then tried to claim a pregnancy occurred and tried to extort him out of money, something she has apparently done to multiple men before. This one actually got called out on the false accusation, on the attempted extortion, all of that stuff. This one actually got called out. Now, within that case, there's a restraining order because Laura Owens apparently takes out restraining orders against a bunch of people. So if you want to be restrained, just ask. I mean, I hear kind of nutty. No, I'm just kidding. That's a joke. Don't ask. But she takes out restraining orders and then, you know, goes after them and stuff. So there's a restraining order in this case. I don't know all the details, but Megan Fox, who on occasion is correct about some things, she has said you have to watch this hearing. You have to watch this hearing. It's gonna piss you off and all that stuff. So that's perfect. That's perfect. So we're gonna be doing that tonight at 11 p.m. Central. I'll get the link put up in advance, and then that'll be that. So let me get the locals chat pulled up. We're almost ready to go. And then we're going to start this hearing up right after. Once I get my screen set up on my end, which is the most important thing. I don't care what you guys see. I care what I see. That's not true. This is what you guys see. Once we do that, we'll be going for it. So where is, it's not that. What is this called? Just have it labeled that? That doesn't seem right. Okay, so it's this one. No, it's not that one. It's this one. There we go. Perfect. Perfect. Okay. With that, whoever said they would lose the tie on this outfit, I respectfully have acknowledged your opinion in my head. I have discarded it, but not because I don't, you know, like, I think I could see it. I think I could see it. I just liked the way this Trinity tie knot worked with the down left tie swoop. And I wanted to, and I also like the blue in the tie doesn't come through on the camera as well, but it does in real life. The blue on the tie and the jacket is fun. Otherwise, there's no blue. Tying it together. Not that you need it, but long story short, that's why I made my decisions. You can disagree with me. That's okay. What is up, Melody Coacher? Welcome to the show. As a reminder, super tips are available and fully in stock. This jacket is blue. What are you talking about? And there's, you can't see it as well because of the studio lighting, but the dark stripes are actually blue on the tie. Has to do with how the lights hit it. It doesn't matter. It doesn't matter. So we're going to go ahead and get started. Let me see. I'll put the super tip link in the two chats, and then we're go. We had some members only content, not last night, but the night before. You guys should check it out. It was a lot of fun. I think, I don't know, it was fun for me. Let's see. Let me check out super tips. Put these in the chats. Pin, and then. As always, there's no requirement. There's no monetary requirement for this show. You can participate to your preferred level. What is that? To your preferred level, and it is all appreciated. I love to have you here. The free things that you can do, like clicking share, those things help a ton. I really like that, and just chatting, leaving comments. Those are huge for me. And they're all very much appreciated. If you want to contribute to the show, either through Super Chat, Rumble Rants, or Super Tips, or whatever, please feel free to do so. But it's not what it's about. It helps me do the show, and that determines how often I get to stream and all that stuff. But it's not why I do the show, and it's not required. I'm going to do the show either way. So if you want to participate in that way, it's the best ways to get my attention. But you are welcome to just utilize the free chats, which I do try to watch along with those. And if you have something and you want to say it, it might catch my eye. No promises. No promises. You have to be a pretty boy to catch my eye. I didn't say that. All right, so here's where we left off. We're a little over an hour into the 7-hour hearing. Not great on time management from my end, but we're gonna soldier on. And without further ado, we are in the rebuttal. So the defense is up. The defense's motion right now to continue out this pretrial hearing for another 6 months while they allege that exculpatory evidence that they're entitled to hasn't been provided. They've made that argument. The state came up and made their counter argument. Their counter argument is basically like they're going to get all this stuff. They have what they need for the pretrial preliminary hearings to determine probable cause. But because of the reduced standards to determine probable cause versus securing a conviction, and because of the deferences that the state is entitled to in a probable cause determination, there's no reason that they need at this point this allegedly potentially exculpatory evidence. My personal theory is that the defense doesn't care if they win this. They would certainly like the extension. I think that's true, but I don't think the defense ultimately cares whether or not legally they win the extension. What they wanted, in my opinion, was the headline that there was a fragment of the bullet recovered from Charlie Kirk, that the ATF, and there's an ATF report on that fragment that says that they had trouble lining it up to the rifling on the bullet, and the ballistics was not 100% clear or something. I believe there are other ballistic reports that contradict that, but that doesn't matter. The defense wants that one as exculpatory evidence. The state does not plan on introducing that report for obvious reasons. That report doesn't help the state's case, and they're under no obligation to produce facts that don't support their own case. It's not even that they undermine the case, because they really don't. They just don't support it. They don't move it forward. They keep the ball where it is. And so the defense is using that, though, to raise this specter that there's confusion about the bullet, that there's confusion about this case. And the defense, I think, has already achieved this. I think they got their preferred outcome. And what they want to do is drive the public commentary. They want to keep the online commentary and using this word as the media would use it. They want to keep the conspiracy commentary fed. They want this idea that there's something against their client to be out in the world. They want this idea that the government isn't to be trusted, that things are going to be held back, that the testing was done that supports some of the alternative narratives that may not make it into a courtroom, but they certainly make it onto social media and popular media. And with the specter of that out there, they may be able to kind of, even though the jurors are going to say they're not familiar with those things, if they can get those things to ping the minds of potential jurors, even if they're not familiar with it, they may go, oh yeah, like, I don't know about this. I thought there was something else. Even that little bit can be enough to help their client. Plus, they're fighting a death penalty case. They want public perception to be that even if Tyler Robinson is found guilty, he's not so obviously guilty that a death penalty is warranted. They want part of their job is to, even if he goes to prison for the rest of his life with no parole, to have the death penalty taken off the table. They want to do that. Part of the way to do that is to change the public narrative around it to make it seem offensive to go for the death penalty in the case. And I think they've gotten what they want out of this from the headlines, but they are fighting for it, as obviously getting the legal result would still be beneficial to them. They still want more time. They still want the record to develop. And importantly, they want chatter out there about this. And they want more time. Here's another thing. They want something to develop that helps convince the judge that this shouldn't be televised for what, their particular purposes. They don't want this televised. They don't want this trial live streamed. Obviously self-interested, but, I disagree with that. I think you allegedly murder someone at a public event. I don't see many reasons for the trial to not be televised. If there are minors or certain people who need to be protected involved in the trial, they can obviously be dealt with in the way that they're dealt with in most of these trials, in which that for the time that they're testifying, cameras won't be allowed. And audio won't be allowed, and the transcript from those portions could be protected. You can see this if Charlie Kirk's kids are called to the stand or something. There's no reason to expose them to public scrutiny and a bunch of trauma associated with the loss of their father. You minimize the impact. I'm not saying they should call Charlie Kirk's kids to the stand. I don't even know how old his kids are, or if they can talk, or maybe they're different. Who knows? It doesn't matter. But that it's just an example of the type of witness that they might have an interest in protecting. So without further ado, let's go.
State wants to offer into evidence at the prelim, but we're talking about DNA reports. And I do want to say, however, that we are not suggesting that the preliminary hearing be postponed until this dispute about the destructive testing of this bullet fragment is resolved. But it was a federal law enforcement lab that said, we're not going to permit a defense expert to observe the destructive testing, and we're not going to videotape the destructive testing. We're going to do this behind closed doors. But that's not what we're talking about here today. That's a different issue for a different time. And
okay, so one of the issues here that he's talking about, although he says it's not a part of this thing, is the idea of destructive testing. A lot of the testing that's done on things is destructive. Even if it's not completely destructive, it alters the nature and character of the evidence. All right. So, for example, to bring this into something that's more familiar to me, and may have become an issue had we gone to trial, but we didn't. So I'm not complaining about this. It's just it was part of a potential strategy. Something to call into question was that the testing of the substances found in my house, for example, we demanded in our discovery request that we would be able to have an expert present for any testing that could be quote unquote destructive. Now, drug testing of a substance itself is necessarily destructive to the amount that's tested. So even though it's a very small amount, you may only have a few milligrams that are required for each test. Those tests are destructive if they test to confirm the substance's composition. If you do like a cocaine test or whatever, it involves a couple different chemicals. You take a small amount of the powder, you mix it with a saline, you add the chemicals to the saline, and then it turns a specific color if cocaine is present. And then you have other things to test for like fentanyl or methamphetamine, et cetera. All of these tests are different. There's not like a catch-all test. And so necessarily some of those amounts of the drug are going to be taken for that sort of testing. And then necessarily you've got criminal charges based on the volume, the mass of how much stuff was there. Well, doing destructive testing reduces the resultant mass. So you can see why a criminal defendant, maybe someone who's like really close to, remember my initial charging documents were 26 grams and the cutoff is 25 grams. So ultimately the testing was 19 grams, but you could see why I would want to have an expert there to watch the testing process and see how much of the material was destroyed, for example, because they might say, well, we had X amount of material and X amount was just Y amount was destroyed. But if Y amount is a lie, or was maybe they inappropriately performed the test and had to grab another little scoop, et cetera, you could see how these numbers, which might really matter, become really critically important to have a second-hand observer for them. Now, that was not done. They did the destructive testing without us having an expert there. So in theory, we could have challenged that evidence as we got to trial. We could have made a motion in limine to say that any of the evidence of the testing and confirmation process done by the Minnesota BCA should be excluded. We would likely lose that in some capacity, but we may get some sort of minor victory. Had we gone to trial, that would have been an issue. But without going to trial, you know, that isn't an issue. And that's what this guy's saying here. So sorry to make it about me, although it's always about me. But I figured a good, easily understandable analogy might be here. They're saying that destructive testing was done on the fragment or some fragment, and that they were not able to have an expert present to witness the destructive testing. Well, now you don't have this piece of evidence to be observed by the defense. So how can the defense meaningfully rely on, the state's representation of what happened? That's a good question. How that's handled, he says not today.
I don't think it has anything to do with when the preliminary hearing occurs.
Mr. Novak, just to be consistent, do you have some final thoughts as your time is coming to a close?
Yes, thank you. My final thought is that this court should direct the state attorneys to find out when the data files will be produced. And once we know that date and they actually are produced, then we've already told the court that there's a concrete amount of time that our experts need in order to analyze them. Otherwise, I've already argued about the constitutional legal principles that are at stake here, and I think that the court has those in mind. I also want to say, finally, the Lopez case has nothing to do with this. I understand it's a Supreme Court decision, but the Lopez case is about a defendant who tried to serve a subpoena on the victim of a sex offense to have the victim testify at the defendant's prelim. That is not what this is about. We're not fighting about a subpoena. We're not talking about victim testimony. It's really not applicable.
Yes, I got a haircut, Alexander.
All right. Well, I'll have questions for both of you. I'll start with Mr. Novak. Again, thank you both for your presentations today in such a succinct manner. The court appreciates that. So one of the questions that's before the court,
You
and
know
Mr.
all
Novak,
about it, I'm
goes
sure.
to the heart of the matter for this court, as the court is weighing whether the continuance should be granted or not. Has defense reviewed all the discovery that has
Gosh, this guy looks like a guy who really wanted to play linebacker but never did. Like he's got like that squatty contact sport build. But then the voice is like, I would love to have touched those pants. Random unbreaded commenter says motion for 1.25 to 1.5 speed. This MF talks so slow. Maybe we'll see. Thank you, Alexander Sobel. I half agree. I half disagree. I've already murdered the hairstylist who did it. Beebs, she's toast. She has been killed, at least in my mind. And just kidding. She's really funny. She's cool. But she did cut it a little shorter than I want, and I am going to give her a ton of grief over it the next time I see her.
has been presented up until this point in preparation for a preliminary hearing set for next month?
We have reviewed the discovery that is tied to the exhibits that the state intends to offer at the prelim where there is discovery available. If the court is saying, have you reviewed the thousands that have the lawyers reviewed the thousands and thousands and thousands of pages of discovery that are well documented in the index that Mr. McBride provided the court privately? The answer is no. Our paralegals are doing their best to organize it, but have counsel reviewed that discovery and have we had a reasonable time to do so? No, because it's gigantic and it's voluminous. We know that some of it has nothing, some of it has been provided in what I guess the state would call an abundance of caution, 30 days worth of surveillance video from UVU. We don't believe that we even need to review 29 of the 30 days. So we're not going to waste time and resources reviewing hundreds of surveillance camera hours without some suggestion that we need to, and we don't believe that we do. Have we reviewed, every FBI report?
Okay, real quick, Samantha's hoe lover. I think it's Samantha's shoe lover, but I'm going with Samantha's hoe lover. Samantha's hoe lover says, I've yet to figure out the stall tactics. He isn't receiving this 30 minutes before the hearing. Look, when you have a client who looks, before I get blasted, I know he didn't do it or whatever, who looks so guilty from a legal perspective, one of the tactics that you have is allowing the record, the murmuring, and the actions by both parties to develop for a significantly long amount of time that it might produce something worthy of so prejudicing your client that you can get a mistrial out of it. You want the other side to misbehave enough that you can call them out on it, maybe, for example. Something like that is more likely to happen on a longer timeline. By necessity of there's more stuff to happen, longer timeline allows that. Tainting of a jury pool, things like that. Improper communications, more discovery failures, et cetera, et cetera, et cetera. There's also the basic notion of getting in the judge's mind early that the state isn't complying with the discovery demands of the defense, and that's a fundamentally prejudicial violation of their rights. And so that also just kind of, again, getting the judge to have this thing in the back of his mind, like, man, we have had a lot of things by the state that kind of are weird, and trying to get just that notion up there that might be their strategy too. So these are the reasons why you might do it.
Interviewing people
Chad
who
Meme says, my
claim
wife's
to
preggo
have
with
known
twins,
Mr.
baby.
Robinson or
Get it,
known,
brother.
his roommate. Yeah, we've reviewed all of that. Have we reviewed the forensic materials that we have received? Yes. Have we reviewed all the law enforcement reports about the events at UVU? I mean, I can only speak for myself. No. Because it's so voluminous that we haven't had that time.
Well, in really the heart of my question is, have you reviewed all the discovery that has been passed that enables you to be prepared for a prelim next month? That's that you're saying is applicable to what you understand the state will be presenting, or what you need to review. Just because the state says they're going this direction, you have to do an independent determination of the discovery on what you need to review to be prepared. And so my question is, have you done that, and are you there?
No. So for example, we received a couple months ago an external hard drive that had thousands and thousands of gigabytes, I don't even know how many, of material taken from digital devices, taken from search warrant returns from what I'll refer to as social media communication platforms, Discord and all of the others. No, I haven't had time to do that. Absolutely not.
But
my clients, so there's a huge download of my client's cell phone. There are downloads of many digital devices. No. Absolutely not.
But my question is, in order for you to be prepared, you've made the argument there's a lot, and there's no dispute that there's a lot of discovery, to say the least. But you've also said that you don't need to review it all. You just want to review what's relevant for the preliminary hearing. And so my question goes to, have you reviewed all the relevant discovery that's been passed to be prepared for a preliminary hearing that you have in your possession now?
That little delay is my fault. I'm sorry.
I can only speak for myself. I'm not going to speak for other counsel.
Boosh, I went over
But
it
the
a little
answer
bit
is
2 days
no.
ago.
The answer is no. But I am not able to, maybe this isn't the court's question, but I'm not even able to approach this fourth category of evidence that the state wants to offer at the prelim, which is the DNA evidence, because we don't have the underlying data files to be able to assess what to do about those reports. So if the court said to me, Mr. Novak, have you reviewed all the drone images that they want to use? Have you reviewed all of the video that they want to present? Have you reviewed all of the UVU surveillance? And by the way, this is a letter we received on April 4th. Have you reviewed all the Discord chats that they want to present? No. And I believe I've been diligent.
Would you like time to confer with your counsel? Because I need to know that information. I need to know.
This is wild. This is wild sauce here. He's like, look, have I ever reviewed all the stuff that they sent us? Well, no. I haven't done that. Not because he can't. He's just like, nah, I believe I've been diligent, but I haven't done it yet. Oh, okay. You're asking for an extension, kind of admitting that you aren't doing the work. So it's a little bit like, he's trying to present like the job of reviewing all this stuff as particularly onerous, like, oh, all these Discord chats and stuff. It's like, come on, we know you're in some furry Discords. We know you can skim that stuff. But no, it's a little bit wild to hear the defense, who's asking for the extension, basically say, I maybe could have looked at some more stuff, but I haven't yet. But I'm good though. I'm good though, court. And the judge is like, do you need more time? Like, let's talk about it.
So that if we move forward with the preliminary hearing, either next month or a different date, that there's effective assistance of counsel moving forward. And that's one of the factors is, have you reviewed the necessary discovery? Typically in criminal cases, defense attorneys say, hey, I haven't been able to for whatever reason. And the court recognizes that, right? Like, I get it, but I need to check that box and say, okay, defense is saying we're ready to go forward with the discovery that has been provided. That's a part I want to be sure is been accomplished. And so as you're presenting for the defense, I would ask you to confer with your counsel, because I understand that you've probably parsed out different areas for each counsel given what's there, but I need that answer as it relates to the defense team.
I now understand the import of the court's question, and I appreciate that the court has clarified that. So we can present that information verbally. We can present it shortly thereafter in writing, however the court wants to present it. But I understand that. So I'll just give the court by way of an example. I have not personally, and I don't think any of the other counsel have, but we should probably take a short break and we can discuss that, reviewed significant portions of the electronic discovery. And when I say electronic discovery, I mean images of device downloads, as well as, sort of cloud-based information produced to the state pursuant to subpoenas for chats, postings, gaming communications. I mean, the primary platform is Discord with a capital D. It's a thing.
Sure.
Right? So
Judge is like, I know Discord. I watch anime. I know all about it. I got it. Random unbreaded commenter says the best part of this motion is Nestor hasn't talked. She will be, though. She will be talking soon. Or at some point.
I think I'm just repeating myself, and maybe that's because obviously I would want to speak with my co-counsel and not speak for them.
I respect that. I understand that you're being cautious and you don't want to present something that someone may or may not have reviewed. So I respect that, and you'll be given time to do that. But that's an important factor for the court to determine.
Totally understand. I mean, we've been
Judge
trying.
Looks
to
like a
focus
judge we
on
had in another case. I just can't
the
remember.
very specific items of discovery that we don't have, which relate directly to evidence that the state wants to present at the prelim, and the court is asking, I think, very helpfully, a broader question. And the court is not challenging. The court is not really confronting us on the question of diligence, so I'm not even going to go there. But obviously, there's been a lot of pretrial litigation on a lot of different issues. And as the court knows from our filing yesterday, there's more coming.
Right. And I appreciate that. And the court's intent is I just want to make sure that when we move forward, we can move forward properly and uphold the constitutional rights of Mr. Robinson and all parties to ensure that what we do is proper and appropriate, because quite honestly, I don't want to do it again. And so, I recognize, and I can do so, that both sides have been very diligent and have worked extremely hard. Obviously, I'm not in your offices. I don't know your communications, but it is evident to me that both sides have. And so the purpose of that question is, that's just a checkbox I need to know to move to that stage. And only your team has that answer. And again, and I recognize the amount of discovery that's been is out there. And so it is no way to impugn defense at all, saying, well, you're not doing your.
I was saying Tyler Robinson. Was I saying Tommy? Shit, I'm sorry. I was probably thinking of Tommy Jordan and hugging him.
Job, you're not working hard. Not at all. I just want to know that answer. And so that's the sole purpose.
And I didn't feel that the court was making those assertions. And I want to say, we hear that the court doesn't want to do it again. Mr. Robinson and his family don't want to do it again. Counsel don't want to do it again. We know that the state doesn't want to do it again. And we also don't want Mrs. Kirk and her family to have to go through it again, because that's actually, in my opinion, the greatest harm to surviving victims in a case like this is the long run when cases don't proceed as the Constitution requires.
And so going to that point that you just asked, so how do you propose the court balance your request for a potentially large, a long delay against the constitutional rights of the victim representative, Ms. Kirk? in her right to a speedy disposition of the case. For example, I noted in your motion, you stated that your DNA expert needs, I believe it was 6 months.
That was her estimate.
And so
Most DNA experts I know don't need 6 months. just a couple minutes, really.
how do we balance that? And I appreciate your statement, but going to your statement as it relates to Ms. Kirk's right to a speedy disposition of a party outside, right? Not counsel from either side, but it seems like we're going to be held to the timeline of somebody outside who's an expert who's saying 6 months. And that concerns the court about that is a potential hang up of, well, we can't move forward until we comport with their timeline. And that's concerning. So how do we reconcile that?
Well, first of all, if the expert needs 6 months, the data files were available in September, which was 6 months ago. And so I actually think, while I will answer the court's question, another important question is, why haven't the FBI and the ATF provided data files that they utilized 6 months ago? And Your Honor can't answer that question, and I can't answer that question, and obviously Mr. McBride can't answer that question. And so I actually think, and I don't purport to speak for the victim representative, but that's a question that the victim representative should be asking, at least through her counsel, is why haven't the federal law enforcement agencies, which took responsibility for this analysis, provided the data? Not the CVs. I mean, I've actually examined at least one of these FBI forensic examiners in another case. I have her CV. That's not my issue. We cited in our reply brief the cases which show that the victim's right to a speedy trial does not, I'm sorry to use this word in the current environment, but that's the word we use, does not trump, lowercase t, the defendant's constitutional rights. We do not want the victim representative and her family to have to wait any longer than we have to wait. But it isn't sufficient for the state to say, we've turned over gigabytes and gigabytes, and the defense,
So many
doesn't really need
gigabytes.
to review it before the prelim.
Like, I saw an article talking about how many gigabytes, like 398 gigabytes. Yeah, there's like a billion videos. They're all in 1080p. We got to stop with this whole like gigabytes thing. It used to be, you used to be able to say like, wow, they've provided so much discovery. It's so, like all of this data, but like gigabytes and gigabytes is just because we have 1080p or even 4K video recordings that are being bandied about like they're nothing. These things take up massive amounts of space comparative to documents. If it was 398 gigabytes of documents, that's one thing. But the amount of video that's involved in this case, it was filmed from multiple angles for all sorts of different phones. It's all been submitted to various people. They need to go ahead and knock that down a peg or two. It's not that important. Without a reference for how much of that is video versus documents, it doesn't really do anyone any good. Plus, like, documents are getting more and more interactive, higher resolution. There's a whole bunch that goes into, the size of a PDF, for example, that you're producing, or the size of, various pictures that you might produce. Are they vectored out? Like, what's the file format that they're using? Like, all of this stuff matters. What doesn't matter is the amount of gigabytes that we've been sending. You could send all of them in effectively the exact same amount of time. It's like 398 gigs. Oh, that's a lot. It's like, that's 2 hours versus 15 minutes in the scheme of the whole trial, especially with months ahead of time. It's completely irrelevant to what's going on. Stop it. You're not on a 96K modem anymore, bud.
That's not obviously in the court.
Speaking of not on a 96K or 9600 modem anymore, we've got Robert Gouveia rating the stream. Thank you so much to Robert. Really, really a tremendous YouTuber, Rumbler, commentator. lawyer, and all around seems like a good dude. If you don't know who he is, you need to go check him out. You will learn something. If nothing else, you'll learn how to be handsome. That's very important. So go check out Robert Gouveia over on Rumble, on YouTube, and wherever fine attorney products are sold. Thanks for raiding, buddy.
I think tends to agree with what I just said, that doesn't make a lot of sense. So we do respect the concerns of the victim representative and her family, but we can't constitutionally shortcut Mr. Robinson's right to the adequate assistance of counsel. And I think, as we said in our brief, when the state doesn't give us the...
This is kind of an interesting argument going on right now. Okay. You have a constitutional guarantee and right under the Sixth Amendment of a speedy trial. All right. That's important to know. In Utah, there's a Utah constitutional right to a speedy trial for the state and for the victim, which is, I mean, that's something. Now, in this case, we have a victim representative because the victim happens to be a corpse. I'm not sifting through the case law. I'm going to assume that the victim's right to a speedy trial transfers to their estate and its representative, but I don't know if that's actually true, but just assumes it for the argument it is. Well, now we've got two rights that are in line with each other. And this defense attorney is saying, whoa. These speedy trial rights can't be used to interfere with the right to effective assistance of counsel. I don't remember. I mean, maybe it's in the Utah Constitution. I don't remember effective assistance of counsel. I don't think that's there. I think you have the right to an attorney. You have the right to remain silent. You have the right to due process. But like, he's now trying to equate by argument the fact that two parallel rights to speedy trial exist implies that a right to a long trial exists, because it might be hard work for the attorneys. I haven't read that one. I haven't read that right. And I could be completely wrong, but like, I'm not aware of that. I would love to see a citation to that. And maybe it is a facet of the Utah Constitution. Absolutely could be. But just saying like, well, you have a due process right. It's like, okay, but due process doesn't mean you get a 4-year trial. Like, okay. The Constitution is the minimum. The U.S. Constitution is the minimum bar for what you are entitled to. And one of those things is a speedy trial. If you waive your speedy trial right, you don't suddenly have a right to an extended trial. Your right is still to a speedy trial, and your right is to due process. That means you have a right to whatever process is due for whatever thing is going on. In this case, you have a right to a trial before a jury and a judge that has a set of rules in the state of Utah, et cetera, et cetera. That's the process that's due. Him trying to conflate this into you have a right for a long trial is really, like, it's interesting, but it's not like a good argument at all.
Data that their law enforcement partners have and have had for 6 months, we can't be constitutionally effective. And you know, and again, I keep talking about Mr. McBride because I appreciate his advocacy, but if the state didn't want to have to deal with Article 1, Section 12, the concept of appropriate discovery, this court's need to apply constitutional standards of reliability, Mr. Gray could have presented this case to a grand jury. And instead, what Mr. Gray did was he filed an information with probable cause that relies on multiple assertions of DNA results. We should have had that discovery under a different rule immediately. If he had reports that are based on these data files, when he filed his information and probable cause, those data files existed. Those data files must have existed on September 15th or whatever the date of the information was. And here we are past April 15th. So I will confer with my colleagues on the court's question. We will obviously answer it because it's an important question. If the court has other questions for me,
I do. And
I'm
so
prepared.
going to the state's argument that there's these four prongs that can be pursued in regards to the categories of evidence, and that the standard is clearly articulated in State v. Virgin, and so my question for you is, if the state's presenting evidence that can meet the standard in any of the four prongs, is it necessary that all the discovery for all the prongs be turned over in order for the defense to be ready to proceed at the prelim?
I'm not going to speculate about how the state's presentation at a preliminary hearing would go as to prongs 1, 2, and 3.
Wait, you're not? It's incumbent upon you to anticipate the state's argument, at least to the best of your ability. In fact, it's an ethical obligation to do so, to present relevant and potential counter arguments and address them in your pleading documents and any responsive documents where argument occurs. So you should be speculating somewhat on what the state intends to do at a preliminary hearing. But the preliminary hearings that you're talking about are addressing probable cause. So you know exactly what the state's going to do. The state's going to introduce the evidence that makes a case, the evidence that, if uncontroverted, leads to a probable cause determination. And that's not that hard to do, especially in this case. For example, you have a confession. I think 2 confessions from Tyler Robinson, in which he claims to have killed Charlie Kirk. Now, a bunch of people can come out and say those are fake, or they're not relevant, or they were coerced, or they're out of context, or they were a joke. And I understand all of those arguments, but those aren't arguments for pretrial or a preliminary hearing. And the state will get the deference that those statements are to be taken as true outside of some really obvious thing that shows that they're not. Like if you can show that those states were manufactured by someone other than Tyler, like if they were made while the phone was in the custody of the FBI or something crazy, right? Like if you have some sort of data to outright throw out the statement, or if they were improperly acquired under the Fourth Amendment, and you can show that at this point in time. If you have those things and you can eliminate things, then you can maybe defeat probable cause. But really, the state's just got to present a piece of evidence, and they'll do more than one, but a piece of evidence that addresses every element of the alleged crimes, if uncontroverted and true. And they get the benefit of the doubt that it is true, and there isn't really an opportunity to controvert it. So just for the probable cause determination, not obviously not for the guilty determination. This is similar to a grand jury. In a grand jury, they can introduce things like hearsay evidence. They can introduce things that will not make it into trial, but that show that probable cause does exist for the charge. And then at trial, it's up to them to try and get those things in. So this is a little bit of a strange statement, again, by the defense. Speaking of strange statements, Exile the Knights of Malta now has become a YouTube member. Welcome.
Nor could I concede that without seeing the way the witnesses testify and which reports are actually received into evidence that they establish probable cause. It's the state that wants to present DNA evidence through summary reports, not through the witnesses who wrote the reports, not through.
Abracadabra says, that seems like avoiding the question, why can't the feds and state provide the evidence they have 6 months ago? Well, a couple things are going on here. The assumption is that the evidence was completely developed 6 months ago, right? Like maybe they had a preliminary report, maybe there's further testing that was being done. I don't know. But the first assumption is that the defense attorney is telling the truth or accurately representing this. And this isn't a nefarious or malicious accusation. It's quite possible that he believes, based on reading a report or an inventory, that something existed at the time that was one, part of discovery, and two, ready to go. Now, the state would have the opportunity then to say, actually, no, this wasn't ready, or this is still being prepared, or et cetera, et cetera, et cetera. Or we haven't been provided it either. We know that there's something going on. We don't answer for federal agencies. Maybe there are different questions involved in the federal agency evidence thing. Maybe the fact that it's federal. Maybe there's some different interests that out there. I'm not saying this is true, but this is a political case, and it could involve matters of national security. Not this one, I don't think. I really don't think so. But like, you could see that a highly politically charged case might involve a matter of national security, and those matters of national security could have evidentiary information come out in the details. I know, oh my gosh, I can feel the testicles warming up, getting ready to be like, they're gonna simp for Israel or whatever. Like, I got it. And you can say that all you want, I don't care. But like, it could be something along those lines. I don't think so in this case, but there's a bunch of reasons why something could appear to be on an inventory 6 months ago that hasn't been presented yet. That's possible. Or, they could have made a determination that the evidence isn't exculpatory, and now the defense is fighting over it and saying, where is it? We think it is exculpatory. We want to see it. And then they'll have their little back and forth about it, and then ultimately they'll probably have to present it, because Brady requires you to kind of default on the idea that it is exculpatory if it might be. And so then that should be provided. But like, there's a bunch of reasons why it might happen. And one other reason is very important, one very common, is that the state is sometimes just an asshole. And that could be the case here. The state could just be an asshole. They could be delaying things, or the feds, I should say. We don't know. We don't know. But just there's always a possibility that someone misread something, someone missed something. I mean, he's flat out said, I haven't reviewed everything they've given me. Maybe they have provided it, and he just hasn't seen it in the file. He's talking about all the gigabytes that have been given to him. I know, like in my case, the discovery would come in this one, it'd be like 1,000-page PDF, right? And it would have a bunch of different shit in it. Like, it's 1,000 pages, yeah, but it's like, maybe it's 100 different items. And one item is like 600 pages and is like a complete medical history of someone. And then the other items are a bunch of little things unrelated to medical work. And you have to just go through and find each one. Discovery is kind of done in a very stupid way. It could be done in a much better way.
Through their own state lab analysts. So it's not for me to comment on categories 1, 2, and 3.
Really quickly, Sunken Cathedral says, why is the prosecution asking for a speedy trial? Is that not unusual? In some states, it's very unusual. In Utah, there's a constitutional right for a speedy trial for the victims and for the state, as well as for the defendant. So they have a right also. Now, he is correct in that the right to a speedy trial under the Utah Constitution can't interfere with another fundamental right. He didn't really say it this way, but it can't interfere with another fundamental right of the defendant. He was trying to say that it could interfere with his due process rights. That's a tall order. That's a tall order to say that due process rights are being violated at this point. Although that could happen, it could happen.
I understand what Mr. McBride is representing, but I can't comment on what this court will think of that evidence. But it's the state's decision to present 3 different DNA reports, at least at the current time, according to the memo that they gave us earlier this month. And it's their federal law enforcement partners who have not complied with that reasonableness test.
Right on point, a complete random says, does bring up another question though. This is a state case being tried in Utah. Why are the feds involved and why would they have access to any evidence not provided to local authorities? And here is why. Very, very simply, federal agencies have sometimes access to better experts than state agencies. We saw this in the Karen Reed case, right? The federal government made ARCA, who's a third-party contractor, but typically for the federal government, they made ARCA available to the parties to do this because ARCA's really, really good at what they do. And so you can have them say that, they're going to have to go to ATF for tracking on the rifle. They can use the ballistics experts that the FBI and that ATF used for it. So the federal government can always make its resources available to the state. And if the state wants to use them, they can. You could try and raise an objection to this, but you're going to run into troubles because, at the end of the day, a court is going to have a hard time saying that the agency that reviews federal ballistics issues is not going to be qualified to review a state ballistics issue if the state is consenting to it. Now, I don't know if there needs to be consent from the defense on that, but again, a challenge to these recognized experts being used would require some sort of basis for it.
And that's got to be imputed to the prosecution because we don't have it. Nobody's accusing anybody seated at council table or over there of stalling out
Mom
anything.
Overlord, welcome.
And I think the court deserves to know why the FBI and the ATF haven't turned over
He's somehow now a member for 1 month already. That was amazing. It was like 1 second. Welcome, Mom Overlord, to membership. I hope you enjoy it quite a bit. Let's see. Someone said something interesting. I don't remember where. I might be imagining it. I can't remember exactly what it was. I don't know. We'll keep going.
these data files.
Well, I understand, but that doesn't get us to where we are today. The why doesn't help us right now.
Well, the why might tell us when. I mean, Your Honor is absolutely right. The better question is when. And then when we get them and our experts look at them, maybe there is a refined assessment about how long that takes.
So my final, I'm sorry.
No.
My final question is I'm trying to avoid a slippery slope of, wait, we need one more thing. We need one more thing. We need one more thing. Are you saying, my understanding is, and I have, I understand to a small degree, given my experience about what you're requesting. You're requesting the lab notes, like all the underlying data that was put in to generate the DNA reports and the findings. Is that my understanding? What you're requesting is that is still outstanding?
What is actually outstanding is, yes, but most importantly, the data, the electronic quantification, digitization of physical evidence taken from our client and certain objects that leads these forensic examiners to conclude that there are matches. Mr. McBride says, oh, there's two different things, and so they're both right because they each independently reach the same conclusion, but they're testing different objects in different labs with different protocols. We don't even have those data. And yes, with respect to, the court may be asking me a question that is better addressed by Mr. Burt, because he's the one who specifically crafted the discovery request. And I know that Mr. Burt has reviewed more of the DNA forensic discovery than I have, but I can tell the court that without those data files, we can't even start to analyze, to understand, to appreciate the conclusions, the statistical analyses, the results of those tests. So yeah, the bench notes and the protocols that were followed, yeah, that's all
The
important.
protocols of the
but
Order of
we
Zion or
don't even
whatever.
have the
Oh
data
no!
files. And there's no reason that I am aware of that has been provided why the ATF and the FBI, first of all, the ATF, why they provided it in the last 3 weeks and why the FBI still hasn't. And so I don't think it's going to be a dribble of this and that and this and that. It should have all been produced, some of it 6 months ago, because we have DNA reports from September of 2025 that Mr. Gray relied upon for his information.
I guess what I'm trying to do is I want a bright line of saying this is exactly what we're requesting, and it's the court's decision if that's necessary or needed to proceed with a preliminary hearing. I just want it to be so clear that we know, okay, it is, hypothetical. We need a blue pen that is Bic or whatever.
So judges here asking for specificity. The defense attorney is, of course, trying to be as non-specific as possible. And again, my smell test on this is that the defense knows that they don't have a strong argument here for what they're ultimately asking for as a subject. They want a notion. They want a notion that the feds and therefore the prosecution are not complying with discovery. And then they wanted the headline. They already got it. I don't know that they're expecting to win the 6-month extension. And I want to raise on occasion he does something right. MLS says, how are they going to get a state court to order the federal government to turn over this information? And that's a really good point, right? Federal supremacy would say that typically a Utah state court can't force the FBI or the ATF to disclose this information in any way normally. I would say this, if I were without any case law on it or anything else, just kind of the first idea that comes to my head is simple. The federal government offered its services in reviewing the ballistics on this case and doing forensic analysis. They offered their experts, and in doing so, I would say that the federal government has submitted to the authority and jurisdiction of the Utah court in regards to this matter. And if that's the case, then the court would have authority over them due to their voluntary assumption of that authority. There's questions about jurisdiction come up a lot, but if someone voluntarily enters the jurisdiction of the court, they can't later make an argument that the court doesn't have no authority over me. Now, I could be completely wrong on that. They may have some other thing. They may have a stipulated agreement, etc. I'm not sure. But to me, and I think that's only fair turnabout. If the federal government says, yeah, we're gonna do the ballistics on this if you guys want us to, they can't similarly say, well, the court can't compel us to produce our documents. So that's my thinking on it. He says, I feel like the court could order the state prosecutor to request the information from the feds, and then if they get anything to turn it over to the defense. I feel like that's the limit. I think under normal circumstances, yes. I think that the court would have no power to exert authority over federal agencies. But I think the federal agencies coming to the court and offering their assistance subjects them to the jurisdiction of the court in the same way in which if you wanted to, you could subject yourself to the jurisdiction of a neighbor state that you've never been to, if that would legally be purposeful for you. But once you do that, you don't then get to say, well, actually, the state doesn't have authority over me. That's my thoughts on it. I don't know. If somebody has a real answer, feel free to share it in the chat and tell me I'm gay and wrong. And I'll say, okay.
So definitive, there is no question. Because what I'm trying to avoid is, well, okay, they provided this, but it's not exactly it. They provided this is not exactly it. And I respect your position. I understand it. I just want to make sure there's no ambiguity. And that's why I'm trying to distill this to its finest point so I know exactly what you're asking. Because when you say data files can be anything. I want it to be clear as day so nobody can say, well, I didn't realize it was that. And you're saying the FBI hasn't turned over the data files. That is a very broad statement. And so I want to make sure.
And again, the judge here is asking, the judge here is asking for a very small wiener. He's like, I'm very intimidated. No, he's asking for very specific things. What do you need me to get for you? And the defense is keeping it as vague as possible. And that's the problem. Mike Paul says, so the prosecutor has evidence the defense doesn't get access to. That's not the argument. And interestingly, the defense is being very careful here and very intentional in saying, we're not even accusing them of doing the wrong thing. The defense or the state prosecution has done nothing wrong. We're just saying we want access to the FBI and ATF stuff. Okay. But like, so if the prosecution has done nothing wrong, it means that the prosecution maybe doesn't even have that stuff. And that it's being held by the feds. And so they're being very careful not to accuse the prosecution of doing anything incorrect, not to accuse the prosecution of withholding anything, in fact, is what he said. But to say that this data does seem to be out there and we want it from the federal government, that's a strange position to take. That's a very strange position to take because typically discovery requests require you to make a demand of the other party for them to put forth their best efforts to acquire data that they reasonably have access to and produce that, not to make some Herculean or impossible effort to acquire something that they don't have access to. And so he's really kind of on a funny line here. And again, along with the admission that he hasn't even reviewed all of the data that he's gotten, I think they're putting up a rather weak position here. But more importantly, the prosecution has asserted very clearly that the defense will get access to this data. He's just saying it's premature for them to be demanding it because this data won't be relevant at a pretrial probable cause hearing because the state is entitled to deference, because the state really doesn't get to have their evidence controverted by another set of facts. And that's what they'd be trying to do. They're saying, well, this ballistic report says maybe the bullet didn't come from the gun, at least the way we read it. But there's another ballistic report that says it does. And they disagree with it. Well, that's great. But in that fight for a probable cause hearing, the state wins, the prosecution wins. They're entitled to that deference. So the state is saying they're going to get all this data when it's time for them to get all this data. But right now they don't need it. It's not relevant. They won't be able to raise it at the hearing. And even if they did raise it, it wouldn't do them any good because it's just a contrary factual statement. And that contrary factual statement will then be resolved in favor of the state anyway. So it's not a big deal. So kind of a strange fight going on.
We distill it to, it is this exactly. So the prosecution can say, okay,
hey, weird Russian
we need
name
to
guy,
communicate
like
with our
that's
federal,
enough.
Their federal partners. Then they can, and they can say, this is what we needed.
You could stop.
But if it's
like,
just a broad, we're missing data files,
irrelevant.
That's difficult for the court to weigh whether it is actually necessary in order for the preliminary hearing to proceed.
So I think then what the court is maybe requesting or maybe suggesting is that there's going to be a continuum from what data we need in order to be constitutionally effective at this prelim versus the continuum from that all the way over to what is more in the nature of expert notice 702 Daubert issues before a trial. And as long
yeah, you need to do that. You need to do that. You're sitting here asking the court for all this stuff. You need to do the thing that you just said. You haven't done it in this hearing. Like, why not? Just tell them what you need. That's what the judge is asking. So this guy is laying out the conflict that the judge has identified for him. He's just restating it, which is completely useless.
As long as the state's position is none of what you're requesting, not even the digitization of the DNA taken from Mr. Robinson and the DNA lifted from these
Digitization of DNA is just getting it on your fingers.
objects, if the state's position is that that's just Daubert discovery, then we can have the conversation with the court, and we can give the court our view of where the line is between what is data that should be reasonably available to us now.
How do they know what they need if they don't have access to it? Really simply, if you know something's out there and you need it, you know what you need. That's that. But see, they can't. What the state is saying, and maybe the state's wrong. I'm not like particularly on their side. I'm just trying to explain the argument. The state is simply saying this. What they're saying that they need to get, they can't even present at the hearing they're asking you to move. It's irrelevant to this hearing. It's relevant to trial. And the state's attorney said this pretty specifically. You know, if we're coming up to trial and they haven't gotten this data yet, yeah, we need a continuance. We need a continuance of the trial, but we don't need a continuance of the probable cause hearing. Again, a report that says that the ballistics on the bullet aren't as trustworthy as we think doesn't matter, because there is a ballistics report that goes with what the state says. You can say that it's not as good. You can say that this other thing supersedes it, contradicts it, obliterates it, etc. But at this stage and at the preliminary hearing, the state will win on their ballistics report, because they have a ballistics report that, if true and uncontroverted, supports the idea that Tyler is the killer. That's all they need. They don't have to have that ballistics report win or even be able to win. They don't have to litigate this out right now. And so the defense is saying, well, we need the other ballistics report. And the state's saying, why? Even if they present it, even if it's better, even if it would supersede ours, we're not at that stage of the trial yet. And so therefore, we're going to win anyway under the rules at this point. And they'll get it later. He's sitting here saying, well, that's Daubert evidence, Daubert evidence. Well, the ballistics report is Daubert evidence. Daubert is the expert witness challenge case, basically, where you challenge the sufficiency and methodology of expert testimony. So you might challenge the scientific method that's applied. You might challenge the sample size. You might challenge that a qualified expert is sufficiently trained in his field, or in the field of study in which he's performing the tests. Like, because you have different forensic fields that are close to each other, but don't necessarily have the same thing. So Daubert is where you find out what the best expert evidence is. And that hearing is to determine which one of those reports wins. But that happens later. That happens after this pretrial probable cause determination. So again, states like, yeah, they're going to get it. They just don't need it now. It won't help them in any way. Probably can't even be presented. And the defense is like, no, we want to we don't know. The defense's job is to know what they need. And knowing that that report exists doesn't mean that they need it at pretrial, because the only things that they need at pretrial are the types of exculpatory evidence would be anything to sufficiently undercut on constitutional grounds the collection of evidence that will be presented at that hearing. If they can constitutionally undermine its collection, like it was acquired in violation of the Fourth Amendment or Fifth Amendment or Sixth Amendment, for example, any of those things, they can undermine those. That's what they're going to be challenging at the probable cause hearing. If the discovery that they're asking for doesn't relate to that, and just a competing report definitely does not, they don't need it for probable cause. Now, personally, I believe that all information should be provided immediately, but that's just not how court cases work out. So please don't mistake this as my personal feelings. My personal feelings are, if it exists and it's done and it's ready, it should be provided right away, because the defense team should have as much time as possible to review and incorporate these things. I agree with that premise, but that's not how it ends up working out in court all the time. So again, just trying to explain those two differences.
Versus what is Daubert. But Mr. McBride's position is we don't even need the digitization of the DNA swabs in order for this preliminary hearing to go forward. So if the court, I'm not trying to obviously put words in the court's mouth, but if the court's saying, I'm not going to go that far, but I need to draw a line somewhere, then we can take our discovery letter, which we gave Mr. McBride, and we can tell the court, these are the things that we think we need in order to be able to go forward in the preliminary hearing, and we acknowledge that these other things are more akin to expert notice, Daubert, and Rule 702 issues. We can do that, and it wouldn't take long, but
Why haven't you? That's the real question. Why haven't you done that? That's the thing the judge is asking.
and I think it's an appropriate way for the court to say, I'm not able to guarantee Mr. Robinson effective assistance of counsel at a preliminary hearing until the defense has these pieces, and the others can wait. So I understand the court's question, but it does require looking at a 3 or 4 page discovery letter and drawing a line somewhere, or maybe it's yes, no, yes, no, yes, no, or you know what I'm saying.
No, but to be quite blunt, that was the hope of the court for today. You're asking for the continuous because some discovery hasn't been provided, but I want to know what that is in order for the court to weigh that.
Well, we will do that today. We'll do it the moment the court wants to take a break. We can do that.
Okay.
And we can tell the court, these are the things that we think that that all the different authorities that I've cited require now versus the things that Mr. McBride is saying are expert discovery. And then the court will make its determination of which bucket each of those items goes in.
Sure, I appreciate that.
I think that's fantastic.
All right, thank you, Mr. Novak. I think I've asked plenty of questions. I want to afford the other side the
Always open to
opportunity
questions, Your Honor.
to have that same experience. All right. All right, turning to the state.
Bittersweet Heart asked, why do I think that there's a delay in producing the materials? I think the state doesn't have them, because I think that this would be resolved immediately if the state was like, oh yeah, we'll send over the report. Like, we've got the report, we'll send it over. I think the reports are in possession of the FBI or the ATF or whatever. There's also, it's not just a ballistics report. There's some DNA reports from the gun swabs and stuff like that. So I think if the state had the things that the defense is asking for, the state would produce them. And I believe that the federal agencies have not produced them to either party. And the defense found out that they existed and was like, hey, we want these things. So that's my feeling on it. The state doesn't have them because the state isn't interested in producing those things, from my understanding. So, like, they're like, we don't have them. We don't really care. They're not part of our case. The defense is like, well, these are out there. We want them. So they're pursuing them now. That would be my guess, because this could be resolved so easy if the judge was like, state, do you have this? And the state was like, yeah. And he'd just be like, well, just email it to him. Like, okay, we're done. I think that would be the solution there. So my guess is that it's just in possession of the federal agencies and not in the state of Utah attorney's office.
All right, so the defense has emphasized that this is a capital case which triggers an Eighth Amendment requirement for heightened standard of reliability at all critical stages of the proceeding. How does the state's proposal to proceed with highly technical, uncross-examinable forensic hearsay reports without defense having access to the underlying data, I use that word loosely, satisfied this heightened constitutional requirement and the defendant's Sixth Amendment right to effective assistance of counsel?
Sunken Cathedral says, so they should just be requesting the gun residue test, et cetera, specifically. They should just be requesting anything that's actually relevant to what's going to be challenged at the probable cause hearing. And again, from a personal perspective, I think they should have access to everything right now, like already. Whenever it was done, it should have been provided. That's just me. But like how it's going to play out, I think they need to be requesting things like that. Now, so interestingly, he was talking about they don't need the time where the digitization or the taking of the DNA swabs and turning them into data on a computer screen. They don't need that report, for example. But they need kind of everything up to that report because there may be a chain of custody issue. Now, if there's a chain of custody issue, they can go to, if there was some sort of Fourth Amendment, Fifth or Sixth Amendment probably Fifth Amendment violation in preserving the custody of that evidence. And if they have a massive custody issue, right? Like we don't even know where these swabs came from or who they are. We don't have any names on them. Well, then they could actually challenge that. They could challenge the existence of the DNA evidence in and of itself because they could challenge the collection or preservation of it. And so that's why I think we got that argument where he says, yeah, up to the digitization though. They can't use the reports that are generated because that's challenging the sufficiency of the analysis, not the constitutionality of the collection and preservation. And so that's kind of the difference that we're stuck with here. And that's the main thing in this is like, are these things being preserved? These are the things you're going to argue about at your probable cause hearing. If you're trying to argue about like the sufficiency of data and the methodology used to do the test, that's later. That's Daubert. And that's what the defense attorney was saying.
Well, my tendency is to say, well, if you require these experts to come in and testify, we're doing the same thing that happened in Lopez, that was rejected by Lopez in obviating the admissibility of reliable hearsay. And I don't think that just because it's a capital case, you throw, the baby out with the bathwater here. The rules are the rules, and they satisfy constitutional.
I hate that expression. Who throws bathwater out? It's like, well, we got bathwater. Woo! Oh, the baby's still in there. Very weird expression. I don't like it. He should be fired.
Muster, and they don't change because it's a capital case. Should we pay special attention to them? Absolutely, we should, and we should keep in mind what's at stake here. But it doesn't mean there's a completely separate set of processes and rules that apply to a capital case, right? It's just that we are very rigorous in the analysis of how we apply those same rules to these facts. So I think reliable hearsay is still admissible, and that's where we are. The rules govern, and the rules clearly don't require expert discovery and expert notice before the preliminary hearing. I don't think there's any way to read the rules to require that.
So real quick summary of this, the state's attorney comes up and says, look, this is all reliable hearsay at this point. We're asserting that these are documents produced by, or that what we're going to rely on are documents produced by experts, et cetera. But we don't need those experts to come in right now because we're not going to be challenging the sufficiency of them at this portion of the hearing. So it's, there's a recognized laboratory with recognized laboratory workers. They're going to do the forensic analysis, and we're going to rely on that forensic analysis for the purposes of probable cause. And we don't need to bring in, the full details of everything. We don't need an expert to explain to us what all of that means. They're going to do that at trial. But for probable cause, they're going to say, look, we've got a test that shows that this guy is the most likely person to have picked up the gun based on the DNA on the, on the trigger and all that stuff. And like that should be the expected result. It's his gun, or, well, it was his grandfather's gun, but now it's his. So that should be kind of like the idea. But like that, we're going to produce that test, and someone's going to say, like, the investigator is going to say, yeah, so I got this stuff. And I determined, yeah, it looks like this guy did it, so we charged him. And that's it. That's all that the state has to do here. And again, the defense isn't going to come in and say, well, you didn't do a good enough analysis of the DNA. The only thing they could say is that DNA analysis is completely constitutionally impermissible. And absent that, it's going to go in. So that's what he's saying here. He's like, we're going to be on reliable hearsay. We're not going to have experts. They'll get their discovery before we're actually challenging the sufficiency of the evidence under Daubert.
All right. One of
Yes,
the other
Fletcher
issues
boy,
that's
I'll be
been
streaming at
brought up
11 p.m.
is defense argues that the FBI and ATF act as your law enforcement partners and therefore are part of the prosecution team. How do you reconcile your position that you only need to provide what is physically present and reasonably available to the prosecutor under Rule 16A2 with the broader definition of the prosecution team? Does the state have an affirmative obligation to compel its federal partners to produce the underlying forensic data for this hearing?
I don't think for this hearing. I think the state does have an obligation, absolutely. I think that obligation, the case laws.
This is getting kind of to the question that MLS was asking earlier. And the judges, of course, he was listening to me days ago, and he basically said, like the federal government has become state partners in this. Are they part of the prosecution team under the rules? And if so, like, how are you justifying that they haven't produced this data? Does the state have an obligation? Does the state have an obligation to compel the government to produce this data? He says yes, just not yet. They would if they still haven't produced it by the time it becomes relevant, or a sufficient time before that. Then yes, there's an obligation for the state to step in and compel it. But at this point in time, again, it's not important for the arguments that we're having. So we're getting a little bit of that answer.
Very clear that obligation certainly applies by trial, right? We've seen numerous cases reversed because the prosecutor has not gone out and gotten material that's in the possession of a law enforcement officer. Some of that stuff, the prosecution probably couldn't have gotten anyway because it was hidden by police officers, right? But yeah, certainly by trial, the defense is entitled to all this material. I can't say all of it because there's probably going to be some objections to some of the material they've requested, like the source code for some of the proprietary software developed in this case or used in this case. But they're entitled to most of that stuff, and we're going to provide it. And that because that's the basis of 702 hearings and also admissibility under 702 and weight questions at trial. But at the preliminary hearing stage, no. The state does not have the same obligations, the same discovery obligations that apply at trial. Now, that doesn't mean the state can put its head in the sand either. What I think is important under Rule 16 is what is reasonably available to the prosecutor. And that's what we're doing here. The point of my April 3rd filing was to say, Judge, look at our over 20,000 documents or files that we provided to the defense. You can see in there, and we asserted at that time we'd provided approximately 100% of the materials that we have, right? And you can see that we're not burying our head in the sand and saying, don't get.
So Complete Random picked up on something the state said. The defense requested source code for proprietary software. WTF did the software murder Charlie Kirk? No, but the proprietary software they're going to talk about, or that they're talking about, likely relates to the forensic analysis. So let's say that you have your bullet fragment, right? And you have maybe some other sample bullets from the gun, and you want to match up the rifling on the bullet fragment to the sampling of the gun, and or to the sampling that they've produced in the lab. And so then what you might do is write an algorithm or some specific piece of software to go do a comparative visual analysis, because ballistics in and of themselves are really, it's as we saw in the Murdaugh trial. The ballistics expert testified, it's more of an art. And it really is, because what happens is some scratches get produced on this metal thing, and then someone goes through and they match up the scratches. And eventually, they go, because those scratches are fairly consistent because they're made by things inside the barrel of the rifle. And so every bullet that goes through them presumably will have a similar pattern, because physics works the same over and over and over again. But there could be some variation, right? Like imagine you have an extreme temperature variation between the two conditions in which the bullet is fired. Do you have issues with the barrel itself contracting or the round itself contracting as it's going through the rifle barrel? If that's the case, you might have the same scratch pattern, but it might show up slightly different measurements. And if you're talking about, looking at things in nanometers of difference, those nanometers might might mean the whole world, for example. So what you might do now with, especially with AI tools that have the ability to examine billions of data points in a way that humans just can't do it, is you might write some sort of custom script that employs an AI to go through and produce a comparative analysis of those scratch marks and account for things like thermal variations, etc. Now, I made up the thermal variation thing. I don't know if that actually does have a measurable impact on it, but it's something I could kind of see happening maybe. So, there are other things that could happen that could change the characteristic of it. Some scratches or etchings could be pre-present on the round itself somehow. If someone, loaded their own rounds into the casing, maybe they scratched the round before it went in. I mean, who knows? Maybe they had some sort of issue and the round got stuck in a thing, and all sorts of stuff could happen. And so you might have a piece of software that tries to account for those variations, whereas a human would look at it and go, oh, nope, this doesn't match. And you bet your ass the defense wants the source code for how that comparative analysis was done. They want to be able to, assess and see if it was a reasonably put together thing by an expert that's, going to produce the predictable and reliable results or not, and they want to then challenge it, of course. So yeah, that would be the conditions under which you'd get source code requests for proprietary programs, those proprietary programs being developed literally for the analyses going on in this case.
Give us anything else, guys. We don't want to know. No, we're saying give us everything. And as soon as stuff comes over, we send it out. And you can see in there the dates that we receive materials and the dates that we push them out. And we're talking within a week, generally speaking, sometimes within days, no longer than probably 2 weeks. We're pushing everything out that we get. And so what is reasonably available to the prosecutor? What does the prosecutor have in his possession? Those are the materials that we've provided, and we've satisfied Rule 16. What we can't do is bury our head in the sand and say, don't give us anything else. And that has not been what's happening here. But neither do the rules require complete expert discovery and discovery of these highly technical data files. And that, your line of inquiry with Mr. Novak just a minute ago raises the importance of this. Yes, the defense, I can't tell you the first date that we had a conversation, an oral conversation where they said, hey, we need the data files. And I remember a conversation we had, I can't remember, Mr. Bird, if it was with you or Mr. Novak, and I said, well, look, assume I'm an idiot. I don't understand what data files are. Tell me exactly what you need. And they say, well, we need the software files that can be used in the software program so our experts can run it. Okay, put that in writing so I understand and don't misrepresent what you want. And so when did they put it in writing? March 25th. So once I got it in writing, that's when we started looking through. I looked through my file and analyzed, do we have this stuff? Have we provided it? Help me understand what's going on. And after I did my analysis, I sent it off to the labs and said, hey, I've done my analysis of what I think we've provided here. Will you guys look at this and see what you think you've provided? And then tell me if if you haven't, get it to me. If you're not going to, tell me why. And we had that communication. We had a communication about that this week with both ATF and FBI. And I think a lot of this material they've requested, we have provided it. Some of this material was provided clear back in October, most of it. A 380-page digital case file from the FBI, disclosed October 24th, date stamp 79, CVs of 3 of the analysts from the FBI. There's case notes were provided October 24th. That's Bates 122.
Oh my God, we've been raided by Rosalind Duke. What's up to Rosalind and her viewers? Thank you for the raid. Thank you for joining us. We're watching the Tyler Robinson hearing that happened on Friday. It's a little dry on the comedy, but it is pretty heavy on interesting legal analysis, questions, arguments, and actually arguments presented not in a combative way at all. It's a different style and strategy for how to do some motion practice. And this is something I think that's really important to these public cases. Not all law and casework and even trial work is so damn combative and standoffish. The prosecution and the defense here are somewhat collaborative. And they're saying, there's stuff, the defense is like, there's stuff that we're missing. The prosecution's like, I'm trying to get it to you. I'm trying to get you what you want, but I need to know what exactly it is. And then they're getting a little pushback from the defense where they're like, well, it's some stuff. And he's like, just tell me and I'll get it to you. But it's not hostile. It's not accusatory. It's really, this is kind of the collaborative motion practice that a lot of law actually is. This is how a lot of law takes place, where the lawyers are like, we know we have this Constitution. We know we have these rules. We want to make sure that this happens within that structure as best as we can. And if something's missing, let's figure it out. Let's do it. And we need the judge's help here to determine what that is. Okay, cool. Let's do that.
And Bates 845 to 848, 73 files of policies and protocols, validation, testing, procedures, analysis,
Oh, if all of Rosalind's viewers could go ahead and report themselves to administration for two things. One, you have to subscribe and you have to like and you have to share or whatever. And then two, you can present yourself for the unrequested touchings. The moderators will handle that.
Efficiency procedures provided October 24th and on December 9th. Now, the ATF lab, they were continuing to do investigations, not investigations, but expert scientific work on this case until the end of February. They chose to wait until they finished to compile all of their case files and to get them to us. We're talking thousands of documents. You don't snap your fingers and have them all together. It takes time to put them together. Once they got,
I didn't say this, but it is true. You must donate $50 or else. Thank you, B. Jefferson. I'll give you your 10% later.
Got them together. They sent them to the SBI for processing. Make sure that the detectives, investigators are aware of the materials, and they provide them to us.
Thank you.
We bait stamp them and send them out. And those are the materials we received this week. Okay, so there's been no delay here, and we've done what's required under the rule. But I think the important point is to go back to the purpose of the preliminary hearing, because what you're talking about here is, have we completed full expert notice? I know Mr. Novak says, well, that's not what we request. Well, that's what we understand, and that's what the pleadings seem to request. And this material, these data files, those are materials covered under full expert notice under 77-17-13, not under Rule 16, and certainly not under there's no mention of when this material has to be provided elsewhere. So I just don't see how this is necessary for the limited purpose of the preliminary hearing.
Cat Slave sent $1, says have $1 for no apparent reason. I like it. That's a good thing. Thank you.
Particularly in light of all the other three categories of evidence here. I think this is why Mr. Novak couldn't talk about whether or not this discovery material of expert material would affect the probable cause determination. This is why the Lopez analysis is so important, is because you can hear the evidence, you can listen to it, and you can say, there's the confessions, there's the circumstantial evidence, there's the video evidence.
Valor News parody member for 2 months says it's been longer, in my opinion. I tell that to Lady Raggets all the time, She's like, well, and I'm like, it's longer in my opinion.
And then there's the DNA evidence. I don't even need to consider the DNA evidence. And there's probable cause.
Right-wing extremists gifting 5 memberships. Thank you so much. That's 7 members for the stream.
And there's no showing the defense can make that would say it's going to undermine probable cause here. That whatever their experts say, best case scenario for the defense is they get an expert that says both labs messed up. It doesn't affect probable cause because you weigh the evidence in the light most favorable to the state with relation to the DNA evidence. And there's all this other evidence anyway, a confession. That's clearly probable cause. So I would ask the court to hold off, deny the motion for now.
And there you have it, guys. There you have it. He's like, we have probable cause. It's pretty clear. We've got this. So they can go after they can go after all of the, you know, forensics and all that stuff. We've got a confession that's clearly probable cause. And he's right. If you've got a confession or an admission, especially one as clear as I shot Charlie Kirk or I killed Charlie Kirk, that you got probable cause in the bag. There's basically nothing that the defense is going to be able to do unless you can produce something that says specifically that was forged or coerced, you know, something like that. Miranda BBY says, hey, thanks for the gifted. You're welcome. I didn't do it, but thank you. But you're welcome. And if you guys did get a gifted subscription, make sure you just say thank you for that. I think that was Right Wing Extremist who gifted that set of subs that hit you there. And it was non-consensual, but we know you liked it, and we're glad that you did. Catslay56 says, oh, I forgot micropeen. I guess I'll put it on the banner. One thing I should mention, the Locals discount code is active. The Locals discount code is Spring 2026. Spring in all caps, no spaces. If you go to Locals and you sign up for an annual membership, that'll take $10 off. So you can get an annual membership on Locals for $40 instead of $50, saving yourself. If you did the monthly thing, it knocks off quite a bit. So if you want to check that out, it is a promotion that's running through the end of this month. So you're welcome to take advantage of it, giggity, and do that if you like maybe don't want to give YouTube money or whatever. If you get a Locals membership that way, you have access to all the members only content. If there's anything that's missing, please let me know and I'll try and get it to you. Yeah, so that's an option. Also, if you're on Rumble and you get a Rumble, if you get a Rumble membership, that also gives you access to the Locals. So in both ways, you get, you get some good benefits. So make sure to check that out. Here we go.
Hear the preliminary hearing evidence, and then let the defense make their showing. And if they can make a showing that undermines probable cause, fine, give them their continuance. And at the same time, have them tell us exactly what data files they're talking about here, because
Right-wing extremist isn't lying. It is your responsibility to buy Nick more sunglasses. I had my eyes on a pair of sunglasses that the lenses changed color when you tap them, and they also have built-in mic and speakers, which sounds really cool. But then I saw a different set of sunglasses that have they have AR built into them, so you can actually have windows of shit inside the glasses, and they have a camera and stuff. And I was like, oh man, maybe that would be cool. I don't know. I probably won't buy either one. Edith Medick gifting 10 memberships. Oh, forcing 10 beautiful members onto the chat. Thank you, Edith. Really much appreciated. Tricky Rich 86 says mine got interrupted. It's actually much, much longer. You keep telling everyone that. Someone's going to believe you. But big thanks to Edith for gifting 10 subs out there. And yes, with any 10 subscriber donation, of course, I'll think of you fondly before going to sleep. Just like, man, that's really nice of Edith Medick. That'll happen. So that's cool. That's my promise to you.
That's exactly what I asked for, and they gave it to me on March 24th, less than a month ago. So that's the process I think you should follow. And, I know the other thing the defense has said is, well, look, the state doesn't have to use this evidence. They're right. We don't have to use the evidence, but we're not going to not use it where the rules allow it. We're not going to back down because of an argument.
I like to subvert expectations sometimes.
We're entitled to use it. We're going to use it. If the court decides not to rely on it, that's fine. So that's my position on that, Your Honor.
Final question, and I appreciate both sides in their presentations. Is there a reason that you recognize that the defense would be entitled to a continuance?
No. Just say no.
Well, I think
They're
there's two
not.
components
They're
to that in
obviously
my
not.
mind.
Like, I don't care if the defense gets it or not, but under the rules, they're not entitled to it. Now, the judge may want to do it. So the judge mentioned the only thing close to a reason that I can think of. The only thing close to a legitimate reason that I can think of was mentioned by the judge just a few minutes ago. And this attorney, if he wants to give any ground to the court, this would be what he should address. The judge said, this is an Eighth Amendment case, which means it's a death penalty case with Eighth Amendment cruel and unusual punishment concerns, which means that every single aspect of this case needs to be done thoroughly, overtly, intentionally, and with full respect of the rights of the accused, and maybe even a little bit extra diligence and extra deference being given anywhere that they can. And that would be the one legitimate place of saying, well, this is an Eighth Amendment case with a death penalty possibility. And since that is the case, that would be the only thing that might entitle them to a continuance in this matter. However, under the rules, there isn't anything specifically suggesting that they should get it. The rules have been followed so far, and they will be fully entitled to a continuance at a later time if there is an ongoing delay as this discovery becomes relevant. That would be the way I think he should address it if he wants to do that. But I think the better answer is, you know what, Your Honor, under the rule, no. No, I don't think so. We've gone through it. We've looked at it, and there's nothing based on what's been presented here that entitles them to a continuance at this point. We need to move this along. The state of Utah recognizes a right for the victim in the state to have a speedy trial, and we're balancing that out with the due process. But they have had all of the process that is due to them. They have had ample responsiveness from us and in discovery, and that will continue as the trial develops. That would be the way I would approach it. I think they should say no. But if they wanted to say yes, it's that Eighth Amendment issue.
First is, in a lot of cases, we will stipulate to a continuance, out of professionalism, preparation.
I'm the Princess says it goes to subscribers that aren't watching this. So this is an important thing. If you want to gift members and you're like, well, but a lot of people are green in the chat, it doesn't matter. You can still gift memberships and they will still go to people who aren't present as well. So it's based on a complex algorithm that YouTube's developed based on participation in the on the channel. And
there's a lot of
and
things.
I don't know exactly what it is. I'm going to go back just a minute because I think he just said something important in response to that. What do you want?
Sorry to interrupt. I made Lewis Griffin.
Oh my gosh, it looks exactly like her.
Want to show it?
Sure. I don't want the volume. Okay, so I guess I'll show this real quick. My daughter plays a game called Tamagotchi Life. Is there anything on here that... No, there's nothing sensitive. Tamagotchi Life. And I don't know why, but she decided to make Lois Griffin. I don't know. Hold on. The lighting. I don't know if I can... The lighting gets kind of washed out on here. You can kind of see it. But anyway, it looks just like her. But why are you... What are you doing? You shouldn't know what Family Guy is. Who's your dad?
Anyway, want to see my other character real quick?
If it's quick,
Okay.
kind of in the middle. This is a show.
I'm sorry. This is very important.
I know. This is critically important.
This one is
Yeah, ESD. I know it's hard to see. It's like the lighting. They won't be able to see
The
this. Either.
rendering.
What is that?
Look, I rendered it perfectly.
That is a they, them, I guess. Who's that? Is there a name?
I just put its name as Tall.
His name is Tall. I can't show it. Like the yellow background washes it out on camera.
Okay, bye.
Okay, get out of here. Did you practice piano?
Yeah.
Okay, cool. All right. I was hoping that would come through a little better because it's like, what I didn't, that's very weird. Also, I have no idea how she knows anything about Family Guy.
Defense would be entitled to a continuance.
Well, I think there's two components to that in my mind. First is, in a lot of cases, we will stipulate to a continuance, out of professionalism, preparation. There's a lot of things that we stipulate to continuances on, but generally we're talking a 2-week, maybe a month continuance. Here, this is a significant continuance that we think violates the victim's right to a speedy trial and affects our ability to get justice.
Your victim is dead. He became a holy man when a bullet entered him. No, it's, yeah, I mean, 6 months is a really long continuance, especially at this pretrial stage.
In the case. But the second component is why, yes, we would absolutely stipulate to a continuance under some circumstances.
Yeah, I know, Ben.
This case, it's hard to say because there's these 4 different categories of evidence that I've told you about. And the failure of any one doesn't mean the rest fail, right? Each one of these categories of evidence really establishes probable cause on their own. So it's hard to say why we would agree to a continuance in this case. I'm thinking of a recent case I had where defense counsel's father died right before a trial. I stipulated the continuance. Okay, sure. Something like that happens. Of course, we're going to extend that professional courtesy to the defense.
It was Chandler Halderson.
I don't think the defense needs to. And this kind of goes to your question to defense counsel. Hey, are you going to render effective assistance? And I'm thinking, if I were in your shoes and they say they need more time to be prepared, yeah, that's a legitimate concern. And would I agree to a continuance for them to be prepared under certain conditions? Absolutely. For example, let's say they hadn't reviewed the 35 exhibits we're going to present, right? We've narrowed it down, given great.
Yeah, this is another issue. The state has, he's telling us now, the state has narrowed down their case. They're going to present 35 exhibits. Presumably, that list of 35 exhibits has been provided to the defense, and they're saying, this is the case we're going to make. So the defense has time. You don't get to do surprises and gotchas most of the time in court. I mean, they come up from time to time, but you really don't get to see them unless something kind of unpredictable happens. All of this stuff is prepared because it isn't about the lawyering. It isn't about the surprise. It isn't about the good twist. It's about what happened. What happened doesn't change because you got a gotcha piece of evidence, right? That a mic drop moment. None of that changes what actually happened. So typically speaking, everybody knows what happened. The question is, or not, everybody knows what each side is going to say happened. And then the question that needs to be resolved is, did it happen? Is that real? The thing that is the real one, that's what the jury or the judge's fact finder, if it's a bench trial, that's what they're there to find out. What happened? And then it's easy to apply the law once you know what happened. You have two competing narratives. So he's sitting here saying we're gonna discuss that stuff, but this at the probable cause hearing isn't where we do this. But we've already prepared and narrowed down 35 exhibits. These are the things they need to focus on. We're not going to bring up these reports. We're not going to bring up any of this stuff. They don't. Why do they need the things they're requesting for this hearing with these exhibits? And he's saying if they hadn't reviewed those exhibits yet and we're coming up to this hearing, I would understand. We could offer them a reasonable amount of time for continuance. But that doesn't seem to be the case here. They're asking for other data that isn't going to matter. And this is a good argument by the state, frankly.
Send Nick that sweet ass money and some extra for the dogs.
Yes, of course. Always do that. It's the best choice you can make in your life. In fact, completely emptying your retirement account. and just putting it up on super tips, like the whole amount, preferably in the hundreds of thousands of dollars or plus, like that's okay. Like that's actually recommended by both all experts and the government.
Later notice than is required by the expert notice statute, in fact. More than a month's notice of all the exhibits and witnesses we're going to call. There's 6 witnesses.
And just so we're clear, I have a hard out in 36 minutes. Hard out for this stream will be over in 36 minutes or less. And then there will be another stream at 11 p.m. Central Time. But this stream has to be 36 minutes or less.
We're going to call. There's about 35 exhibits we're going to provide. Most of those exhibits were provided to them clear back in 2025. The last one I think was provided, maybe I've got it on a list here, but I know you have it in that letter I sent, Mr. Novak. But the last one was provided there's a tool marks report that was provided March 12th. Okay, so under these circumstances, no, they can review these 35 exhibits. We've got plenty of time to review them. I'm sure between all of them, they've reviewed all these exhibits. They're the DNA reports. There's photos of the rifle found, photos of the rounds in the rifle, surveillance video of the defendant on the scene, video of the shooting itself from people in the crowd, those type medical examiner's report, doorbell camera video of the defendant approaching in his car. The defense has all this.
Nestor is still on deck, says Treasure Island. And the engineers who designed it need all the metals in the world. Like, I don't know what deck could support her.
They can be prepared on time. So yes, there are circumstances, but I don't see them in this case.
Thank you.
Your Honor, may I go
Working
back
on it,
to
right-wing extremists.
the request that the court made for a little more clarity? Exhibit F to our motion is Mr. Burt's discovery letter, which Mr. McBride and I have both been speaking about. And Mr. Burt is prepared right now to tell the court which pieces of the discovery letter we view as core discovery that we're entitled to before the state offers any.
Cup of Soothe sent a tip on locals. Says corrupt judge Mark Betters, $330,000 pay to play. And he has Perry the Platypus. So this adds an air of legitimacy to what he's saying. Mark Betters has a pay to play thing, according to Cup O Soothe.
DNA
I
evidence at the
agree.
prelim.
I don't know anything specific,
which
but I agree.
Pieces of that discovery letter are more in the nature of expert notice under Daubert. So if the court wants to hear from Mr. Burt right now, we don't have to delay that, but I want the court to understand that Exhibit F is probably the template for that.
And I'm happy to hear from Mr. Burt. Is more time needed, Mr. Novak, to confer on to my first question about the discovery that's been reviewed?
Yes, I think that would have to happen during a short break.
Would a 15-minute break help accomplish that?
Very much so. I'm sure others would appreciate it.
All right. Well, let's turn to Mr. Burt, and then the court will take a 15-minute break.
We're going to ask some questions.
Mr. Burt.
So, Judge, to simplify a pretty complicated issue, this DNA testing, it's a black box technology. That
Racist.
technician processes a sample, puts it into a genetic analyzer, and what he gets is electropharogram, these little squiggly lines. I'm sure the court's familiar with that. But the machine that they put the sample into generates internal electronic files. And when the FBI or the ATF analyzes the samples, they can adjust the parameters to decide how low of a level do they want to look at the sample. And they have set standards. If it falls below a certain level, they don't want to look at it. That's just the way they do it. And in this case,
Okay, someone asked what the method of execution was in Utah. Lethal injection is the primary method. However, if the drugs are unavailable or ruled unconstitutional, firing squad is the backup. So you get a bullet.
most, what you have on all the samples, they're what are called complex mixtures, up to 5 people in each of the samples. So when they have that kind of a situation, then they use another software program called STR Mix. And they run this program, which also has internal files. And that program supposedly sorts out whether various people can be identified with a sample. So of the information we requested initially, way back on September 16th, we requested all electronic files. And in dealing with the FBI and the ATF for many years, when you make a discovery for electronic files, they know, Mr. McBride might not know, but the FBI and the ATF knows that what you're talking about when you're asking for electronic files is the machine output that can be used by another expert to reconfigure where the DNA readings are taking place. And they can only do that when they have the underlying electronic data from the genetic analyzer. So the FBI was given our initial discovery request, and I don't know, I've done probably 100 cases with either the FBI or the ATF, and when you ask for electronic discovery, you get 2 things. You get the case file, and that contains all the underlying notes of the analyst who is processing the scene. You get the electropherograms, which are the little squiggly things.
Ooh, little squiggly
You
things.
typically get a disk with the electronic files on them. Those files cannot be read by lawyers. It requires software that lawyers typically can't afford, $10,000, $20,000 for the software packages, but they can be
Just broke struggling lawyers.
analyzed by the experts, and that's the information that we're asking for here. And so it's not correct that we didn't ask for this stuff in the beginning.
Now, it is funny because he's like a public defense lawyer. He's like, I can't even imagine how anyone would afford that. Personal injury attorneys are like, la, 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 money, money, money.
We did. We did have a subsequent discussion where Mr. McBride said, I'm unclear on what electronic files mean. And so I did provide in a letter specifying exactly
This guy needs to shut up.
by file extension names exactly what that meant. And in the discovery letter we sent to him, to answer the court's question of what's essential here, item number 6, data files, please provide copies of all computer data files created in the course of performing the testing. And then it specifies both raw data and processed data. These files should include all sample files, FSA and or HID files, matrix files, standard files. Any DNA expert would look at that and know exactly what we're asking for. And again, it's standard. It's all it is pressing a button. They can put that on a disk and give it to you within the day. But for some reason, it wasn't provided. And so that's item 6. That's essential information. And the second essential piece of information in this discovery letter is item 9, the STR mixed data. And under that category, we've listed 6 elements of the electronic data related to the XTR mix. The rest of the discovery requests are broader in scope. And as you were told, that's going to be worked out. But the 2 key elements that we don't have are 6 and 8, or 6 and 9 in this discovery letter. If we had that information, we could get it to the experts. The experts could look at it, see how complicated it is, give you better estimates how long it would take to put together their analysis. And their analysis, we have to depend on them because we don't have the expertise or the software to be able to read these data files.
So, and I appreciate that clarity. That's exactly what I was looking for. My next question is, let's hypothetically assume, and the court is not trying to indicate any direction.
Sure.
So let's hypothetically assume I say that's not necessary to move forward at the prelim. Is your expert ready to testify?
Ready to testify at the prelim?
Yes.
The expert would be prepared to come in and explain to the court what they could opine based on the information they have. But the bottom line of the opinions would be what they stated in their declarations to the court. Without the underlying data, it's impossible to draw conclusions. Part of it, the issue here, the specific issue is the STR mixed data that we're asking for includes the internal validation records. The internal validation records tells the lab how many people in a mixture they can reliably assess using this software. And we cited some cases to the court in the continuance motion where courts around the country are struggling with this issue. There's a certain number, if you surpass, that you can't reliably sort out a mixture. So the experts would come in and tell the court that, but they'd also say, till I see the internal validation files, the underlying data files, I wouldn't be able to tell the court whether they can reliably sort out these mixtures or not, because I haven't looked at what their files say.
So, and I appreciate that, but my question is, have you received the lab notes? I understand, it sounds like in order to simplify it, there's some internal settings for these machines, calibrations and such.
Right.
That is separate than lab notes. Where,
Right.
Now, I just want to make sure I'm on understanding. Have you received the lab notes for the DNA that the state is intending to move forward on as they've given you notice? Have you received that data?
We've received the case file, the lab notes, I'll call them, from the FBI, not the ATF. So we're missing the ATF lab notes. We do have the FBI lab notes, but those lab notes will tell you how the sample was processed up to the point when it was put into the machine. It will not tell you anything about whether the machine reliably spit out the number of contributors in the sample or how they sorted out, how they're matching one of the 5 or 6 people in each sample to Mr. Robinson. That's where we're lacking the information. So I have reviewed the lab note files that tells me how they process the sample. But the critical issue here is, can they reliably sort this out given the complex mixture that they're dealing with? And so that question cannot be answered based on the information that we have and we reviewed.
Thank you, Mr. Road. I appreciate that.
Thank you.
It provides a lot of clarity. All right, let's go ahead and we're at the 12 o'clock hour. Let's break for 15 minutes, come back at 12:15 to confer with defense in regards to discovery. And then we're going to transition to talking about the media in the courtroom. As indicated, the court, it's not the court's intent to issue
ATF and
a ruling
FBI
about
offered their
continuing the
services
preliminary
to
hearing. I
Utah
want to weigh the
for the
evidence, the
forensic
oral argument,
analysis.
the information today, but I am also cognizant of the timelines. And so that ruling will not be delayed because both parties require that, as they should. With that, court is now in recess.
All right.
All right, so we have the court in recess, and with that, I think now will be a relatively good point to kind of stop the video. I'll offer some final thoughts, and then we'll go ahead and we'll close it up for this show, and then I will, of course, resume. Or, well, not resume. We're going to do another show later tonight at 11 p.m. Central. Locals is about to cause trouble, I think. Capital T, and that rhymes with P, and that stands for pool. All right. So here's what we got. We're moving along this hearing. The judge doesn't seem super inclined to grant the continuance at this point. That's my general feeling on it. I don't know if this has been ruled on yet, but if it has and I'm wrong, that's fine. I don't really care. My feeling at this point is that he doesn't seem super inclined to grant the hearing or the continuance for 6 months. Maybe a shorter amount if necessary. But the state seems to have the more compelling argument, and that is that none of the stuff they're requesting is relevant at this stage of the procedure. And so why don't they focus on the things that we are dealing with, and we will focus on getting them that information in a timely manner and making sure that they have what they need. However, if there is something that they need right now, we are willing to do so, but we need some specificity because the defense's allegations of what they need or their assertions of what we haven't provided are vague. And that vagueness makes it really difficult for us. And it is important to remember that these state's attorneys have other cases. This is a ton of work, and they have other work going on at the same time. So having to deal with vague things is sometimes part of the job of being a lawyer. But if you can get a collaborative effort going and nail down with specificity what you want that will be relevant and helpful to your position and provide that, maybe we can make it happen. And that, again, these are the easy things that can be done here without having to continue this out for 6 months. Personally, Tyler has waived his right to a speedy trial. I don't really care about the speedy trial interests of the victim and the state, even though they're in the Utah Constitution. I don't live in Utah, not really my thing. So those aren't the biggest concern for me. Tyler, his right to a speedy trial isn't being violated, so I'm not really concerned about that either. I do think it's a little premature to say his due process rights or his right to effective assistance of counsel, in so much as he has one, that those would be violated by proceeding on the current schedule. I don't think that that's right based on what we've heard. What we've heard was a very broad request for a bunch of things that will come into play later that aren't really necessary now. And outside of the defense putting forth a compelling argument that these things are required now, specifically for the hearings that they have coming up and the arguments that they're going to make, I don't see why the judge would grant that or grant any compelling motion to compel. There's ample time for them to get this information prior to moving into the pre-trial evidentiary motions and then to trial itself. And the judge has stated and the state has stated both that they'd be willing to do the continuance if necessary, if the delays persist as things become relevant. So I think there's just no reason to do it at this point. But if the defense is able to get a couple specific things that they believe that they're missing, and those can be provided by the state, great. Cool. Fantastic. Again, I think the defense's main goal here, the main goal was the headline. The headline that there's a report from the ATF that says that the ballistics don't show the bullet fragment recovered from Charlie Kirk as coming from the gun. That media and public narrative about this is the most valuable thing. Everything else was ancillary. Of course, they're going to do their job and try and get a continuance because it's only in their benefit. It does not harm them in any way to continue this case out. It only helps the defense. It helps the possibility that the state will do something incorrect. It helps the possibility that the public narrative will blow up, that a jury could be tainted, that something could be set up for a mistrial or something later. All of these things benefit the defense, and it's up to them to try and get that. But the main thing they needed was to have a little bit of a counter narrative shot, because no matter what you believe about the competing stories online, the story that's going into court is a very compelling one that Tyler Robinson is guilty. Multiple confessions, pretty solid analysis of the gun, a forensics report that says that the gun or the bullet fragment does in fact match the rifle itself. Like, these things are all there. And I think it's 2 specific confessions. Those 2 confessions are going to bury him if nothing else will. They need to disrupt that narrative going into it for any number of reasons, even if it's to make something go wrong. That's their main hope here. Also, disrupting that narrative disrupts the narrative that supports the death penalty. If there's any any, I don't want to say doubt, but if there's any confusion about like the mental state or whatever of this guy, that will lead to a sufficient amount of public sympathy and sympathy from the bench to eliminate the death penalty and sympathy on the jury. It's probably a jury question. All of those things could be very critically important to him, and a delay and a counter narrative fosters those sorts of results. So that's what they're going for, but it's that headline. Questions about the bullet. It's not as rock solid as they presented it, and that's where it starts. So I think they've already accomplished that. Everything else is ancillary. I've said all this, but I wanted to kind of wrap it up here in a nice little bow. We're going to continue watching this as we go. There's a lot of it left, and hope you'll join me for that. But tonight, Megan Fox is going to join me. We're going to be talking about Laura Owens, the tonsil twins case. This is a woman who alleged that she was pregnant, even though she only gave some sloppy toppy and didn't actually have vaginal intercourse with someone. She alleged that she was pregnant with twins, tried to extort money out of him, and he fought back. And now she's charged with a whole shitload of felonies. This is a restraining order hearing that's happening within that case. And I think it involves her lawyer, David Gringus. I'm not 100% sure, but I think so. Should be fun, should be funny, should be ridiculous. And we'll get to take a peek at that. That's tonight at 11 p.m. Central. Tell your friends, tell your children, tell your wives and husbands, tell your side pieces, tell everybody. Make sure they're there. I want to see them all fighting in the chat. That'll be great. Other than that, thank you guys, everybody who sent in memberships and who sent in chats. Very much appreciated. Check out the Locals promo code SPRING 2026 if you're interested in an annual membership at a discount on Locals. If you're already a subscriber on Locals, I believe you can still do that. It'll just renew now and stuff like that. But up to you guys to check that out. And, Gingras, not Gringus, Gingras. So, all right, guys, until a little bit later tonight, I'm going to make the link, and then I got to do a little bit of dadding. But until later tonight, I will catch you guys then. Have a good evening. We learned nothing. Thank you again. That's on you. That's on you. I explained plenty during this hearing. But you guys have a good night. I'll catch you soon. Peace. Peace.
So pour out an odd bag of more at Lafroy. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Blaming tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for